Welcome to the Ask Junior Monthly Judgment Podcast. I'm Priya Sharma, and joining me today is Arjun Mehta. Before we dive in, we'd like to remind our listeners to like, subscribe, and share this podcast if you find it informative. Your support helps us reach more people interested in understanding key legal judgments.
Hello, everyone. We're excited to be here. Today, we'll be discussing some of the most important Bombay High Court judgments from September 2024. We've handpicked these cases for their significance and the insights they provide into various areas of law.
That's right, Arjun. We've carefully selected these judgments to give our listeners a comprehensive view of recent legal developments. Let's start with a case that caught my eye. Atul Ashok Mundada versus the state of Maharashtra. This one's all about the limits of judicial discretion in ordering police investigations.
Absolutely, Priya. This case is a great example of how the courts balance the need for investigation with the protection of public officials. The petitioner, Atul Mundada, had asked the lower courts to order a police investigation under Section 156(3) of the Criminal Procedure Code against some public officials. But both the judicial magistrate and the additional sessions judge rejected his request.
And the High Court upheld those decisions, right? Can you break down the reasoning for our listeners?
Certainly. The High Court found that the lower courts had exercised their discretion appropriately. They looked at three key factors. First, the allegations made by Mundada didn't seem to disclose a prima facie cognizable offense. Second, the acts alleged were done by the officials in the course of their official duties. And third, Mundada hadn't obtained the necessary prior sanction under Section 197 of the Criminal Procedure Code to prosecute these public servants.
That's interesting. So it seems like there's a higher bar when you're trying to investigate public officials. Can you explain a bit more about this prior sanction requirement?
Absolutely. Section 197 of the Criminal Procedure Code is designed to protect public servants from frivolous or vexatious criminal proceedings for actions taken in the course of their official duties. It requires that before a court can take cognizance of an offense alleged to have been committed by a public servant, there must be sanction from the appropriate government authority. This is to ensure that public servants can perform their duties without fear of unwarranted criminal prosecution.
I see. So in this case, the lack of this sanction was one of the reasons the courts refused to order an investigation. But what about the nature of the dispute itself? Did that play a role in the court's decision?
Absolutely, Priya. The High Court observed that the dispute appeared to be about the disbursement of compensation for land acquired by municipal authorities. The court felt that this was a matter that should have been pursued through proper legal channels, rather than resorting to criminal proceedings against the officials.
So essentially, the court is saying that not every dispute with public officials should be turned into a criminal matter, right?
Exactly. It's about using the appropriate legal avenues for different types of disputes. And in this case, the High Court not only dismissed Mundada's applications, but also imposed costs of over $25,000 each on him to be paid to the respondent public officials.
Wow, that's quite a strong message from the court. It seems they wanted to discourage frivolous criminal complaints against public officials.
Absolutely. This judgment really underscores the importance of having concrete evidence and following proper procedures when alleging misconduct by public officials. It's a delicate balance between holding officials accountable and protecting them from harassment.
Thanks for that comprehensive breakdown, Arjun. Now let's move on to another interesting case from September, Deepak Kailas Aglave versus the state of Maharashtra. This one deals with externment orders, which I think our listeners might find quite intriguing.
You're right, Priya. Externment orders are a fascinating and somewhat controversial aspect of Indian law. In this case, the Bombay High Court quashed externment orders passed against the petitioner under Sections 56 and 59 of the Maharashtra Police Act.
Before we dive into the specifics of this case, can you explain what exactly an externment order is for our listeners who might not be familiar with the concept?
Of course. An externment order is essentially a preventive measure used by law enforcement. It allows authorities to ban an individual from entering or remaining in a specific area for a certain period, usually if they believe that person might commit offenses or disturb public peace in that area. It's a powerful tool, but also one that can potentially infringe on personal liberties if not used properly.
That's a great explanation. So, in this case, why did the High Court quash these externment orders?
The court found several issues with how the authorities had handled the case. First, they didn't have sufficient objective material to justify their subjective satisfaction that the petitioner was involved in offenses involving force or violence. This is crucial because externment is a serious measure that needs solid justification.
That makes sense. Were there any other procedural issues the court identified?
Yes, there were quite a few. The show cause notice issued to the petitioner didn't adequately disclose the nature of the allegations against him or explain why witnesses were unwilling to testify. The court also noted a lack of a live link between the last registered crime and the initiation of the externment proceedings.
Can you elaborate on what the court means by a live link?
Certainly. A live link in this context refers to a close temporal connection between the alleged criminal activities and the decision to initiate externment proceedings. If there's a significant gap in time, it weakens the justification for externment. The idea is that externment should be used to prevent imminent threats, not as a punishment for past behavior.
I see. So it's about ensuring that externment orders are used as a preventive measure for current threats, not as a retroactive punishment. Were there any other issues the court found problematic?
Yes, the court also criticized the vagueness of witness statements and noted that the authorities didn't seem to have properly applied their minds to the case. This highlights the importance of thorough and careful consideration when issuing such serious orders.
This case really underscores the need for authorities to follow proper procedures and have solid evidence when issuing externment orders. It seems like a delicate balance between maintaining public safety and protecting individual rights.
Absolutely, Priya. This judgment serves as a reminder that while externment can be a useful tool for law enforcement, it must be used judiciously and with proper safeguards. The courts play a crucial role in ensuring that these powers are not misused.
Thank you for that detailed explanation, Arjun. Now let's move on to another case that caught my attention. Hitesh Santosh Shinde and others versus the Divisional Commissioner and other. This one also deals with externment orders, but with an interesting twist involving family members.
You're right, Priya. This case adds another layer to our understanding of externment orders. The High Court of Judicature at Bombay allowed the writ petition filed by the petitioners and quashed the externment orders passed by the Superintendent of Police Jalgaon and the Divisional Commissioner Nashik.
What makes this case particularly interesting?
The fascinating aspect of this case is that it deals with the question of whether family members can be considered a gang under Section 55 of the Maharashtra Police Act for the purpose of externment orders.
That's intriguing. What did the court say about this?
The court actually held that family members can indeed be considered a gang under Section 55. However, that wasn't enough to justify the externment orders in this case.
So, even though family members could potentially be considered a gang, the externment orders were still quashed? Can you explain the court's reasoning?
Certainly. The court found that while family members could theoretically form a gang, the authorities didn't have sufficient objective material to justify their belief that the movement or encampment of this alleged family gang was causing or likely to cause danger, alarm, or reasonable suspicion of unlawful designs.
That's interesting. So it's not enough just to label a group as a gang. There needs to be concrete evidence of their activities causing a threat to public order?
Exactly. The court looked at the nature of the crimes registered against the petitioners and found that they appeared to be individualistic in nature. There wasn't evidence to show that they were affecting the common man or their property in a way that would justify externment of the entire family group.
This case seems to highlight the importance of having specific, concrete evidence when issuing externment orders, even when dealing with groups like families that could potentially be considered gangs under the law.
Absolutely, Priya. The court also emphasized the need for a live link between the registration of crimes and the initiation of externment proceedings, similar to what we saw in the previous case. This reinforces the idea that externment should be used as a preventive measure for current threats, not as a punishment for past actions.
It's fascinating to see how the courts are refining and clarifying the use of externment orders through these judgments. It really underscores the delicate balance between maintaining public order and protecting individual rights.
You're absolutely right. These cases show that while the law does give authorities significant powers to maintain public order, the courts play a crucial role in ensuring these powers are not misused. It's a constant process of refining and balancing these competing interests.
Thank you for that insightful analysis, Arjun. Now, let's move on to a case that deals with a completely different area of law: Indo-Allied Proteins Foods Pte. Ltd. versus the state of Maharashtra. This one's all about government tenders and judicial review of administrative decisions.
Yes, this is an interesting shift from criminal law to administrative law. In this case, the Bombay High Court was dealing with a challenge to the rejection of bids in a government tender process.
Can you give us some background on the case?
Certainly. The petitioners had submitted bids for a government tender, but their bids were rejected. They then approached the High Court, challenging this rejection as arbitrary and contrary to the terms of the tender.
And what did the High Court decide?
The High Court ultimately dismissed the petitions, holding that the rejection of the petitioners' bids was not arbitrary or contrary to the tender terms. The court emphasized the principle of judicial restraint in matters involving technical evaluations of tenders.
That's interesting. Can you elaborate on what the court means by judicial restraint in this context?
Of course. The principle of judicial restraint in tender matters means that courts generally avoid interfering with the decision-making process of the tendering authority, especially when it comes to technical evaluations. The idea is that the tendering authority has the expertise to make these assessments, and courts should not substitute their judgment unless there's clear evidence of arbitrariness or malafide.
I see. So in this case, the court found no such evidence of arbitrariness?
Exactly. The court deferred to the interpretation of the tender conditions provided by the tendering authority, finding it to be reasonable and in accordance with the law. They emphasized that it would not be appropriate for the court to interfere with the decision, particularly given the public interest in the timely distribution of food kits for an upcoming festival.
This case seems to highlight the balance between judicial oversight and respecting the expertise of administrative bodies. Are there any broader implications we can draw from this judgment?
Absolutely, Priya. This judgment reinforces the principle that while courts have the power to review administrative decisions, they should exercise this power with caution, especially in technical matters like tender evaluations. It underscores the importance of a well-reasoned decision-making process by administrative bodies, as this can help their decisions withstand judicial scrutiny.
It also seems to emphasize the importance of public interest considerations in such decisions.
You're right. The court explicitly mentioned the public interest in timely distribution of food kits as a factor in its decision not to interfere. This highlights how courts balance various factors, including public interest, when deciding whether to intervene in administrative decisions.
Thank you for that comprehensive explanation, Arjun. It's fascinating to see how these principles play out in real-world cases. Now, let's move on to another case that caught my eye: Just Universal PV Limited versus the state of Maharashtra and others. This one also deals with government tenders, but with some interesting nuances.
You're right, Priya. This case provides some additional insights into how courts interpret tender documents and the extent of their powers in reviewing tender decisions.
Can you give us an overview of what happened in this case?
Certainly. In this case, the petitioners were disqualified by the Technical Evaluation Committee for not meeting the eligibility criteria specified in the tender document. Specifically, they didn't meet the requirement under condition number PQ5, which related to providing manpower or laborers.
And the petitioners challenged this disqualification in court?
Yes, they did, but the High Court upheld the disqualification. The court found that the interpretation of the term providing manpower laborers by the tendering authority was reasonable and in accordance with the overall purpose of the tender.
This seems similar to the previous case we discussed. Is the court applying the same principles here?
You're absolutely right to notice that similarity, Priya. The court is indeed applying similar principles of judicial restraint. They emphasize that in matters involving the interpretation of tender documents, courts should defer to the interpretation provided by the tendering authority unless it's manifestly arbitrary or unreasonable.
I see. So the court is saying that as long as the tendering authority's interpretation is reasonable, even if there might be other possible interpretations, the court won't interfere.
Exactly. The court is recognizing that the tendering authority has the expertise to interpret these technical documents in light of the overall purpose of the tender. Unless their interpretation is clearly unreasonable or arbitrary, the court will respect that expertise.
Were there any other factors the court considered in this case?
Yes, similar to the previous case, the court also noted that public interest was a relevant factor. They mentioned that the timely distribution of food kits for an upcoming festival was important, which seems to have influenced their decision not to interfere with the tender process.
It's interesting to see how the court balances these various factors: the reasonableness of the interpretation, the expertise of the tendering authority, and the public interest. Are there any broader lessons we can draw from these tender cases?
Absolutely, Priya. These cases highlight a few important principles in administrative law. First, they underscore the importance of clear and unambiguous language in tender documents. Second, they show that courts will generally respect the expertise of administrative bodies in technical matters. And third, they demonstrate how public interest considerations can influence judicial decision-making in administrative law cases.
Thank you for that insightful analysis, Arjun. It really helps to see how these legal principles are applied in real-world situations. Now, let's move on to a case that deals with a completely different area of law: Santosh Vishnu Mardikar versus Arun Shamrao Mardikar. This one's about trademark infringement, which I think our listeners will find quite interesting.
Absolutely, Priya. This case from the Bombay High Court provides some valuable insights into how courts approach trademark infringement cases, especially at the interim stage.
Can you give us an overview of what happened in this case?
Certainly. The plaintiff in this case had filed for an interim injunction against the defendant, alleging trademark infringement. However, the High Court dismissed the plaintiff's claim, finding that they had failed to establish a prima facie case of infringement.
That's interesting. What were the key factors that led the court to this conclusion?
There were a few crucial points. First, the court noted that the plaintiff wasn't actually using its registered device mark on its product packaging. This is important because trademark law generally protects marks that are in use, not just those that are registered but unused.
Secondly, the court found that the defendant's packaging was sufficiently distinct from the plaintiff's registered trademark. This suggests that the court didn't see a likelihood of confusion between the two marks, which is a key element in trademark infringement cases.
I see. So it's not enough just to have a registered trademark, you need to actually be using it, and there needs to be a real likelihood of confusion with the alleged infringing mark.
Exactly, Arjun. Trademark law is designed to prevent consumer confusion and protect the goodwill associated with a mark. If a mark isn't being used, or if there's no real likelihood of confusion, then the rationale for protection is weaker.
That makes sense. Were there any other interesting aspects of this judgment?
Yes, there were a couple of other points worth noting. The court relied on precedents that allow examination of trademark validity at the interlocutory stage. This is significant because it means courts can consider the strength and validity of a trademark even in preliminary proceedings rather than assuming its validity.
The court also noted the defendant's ability to avoid liability by distinguishing its goods. This highlights the importance of product differentiation in trademark law.
It sounds like this judgment provides a lot of guidance for businesses on how to navigate trademark issues. What do you think are the key takeaways for companies?
You're right, Priya. There are several important lessons here. First, Companies should ensure they're actually using their registered trademarks on their products. Second, they should be aware that courts will look at the overall impression of product packaging, not just the trademark itself, when considering infringement claims. And third, companies accused of infringement should consider ways to differentiate their products to avoid liability.
Thank you for that comprehensive breakdown, Arjun. It's fascinating to see how these complex legal principles play out in real-world business disputes. Now let's move on to our final case for today, Kunal Kamra versus Union of India. This one deals with freedom of speech and the regulation of online content, which I think is a hot topic for many of our listeners.
Absolutely, Priya. This case touches on some fundamental issues regarding freedom of expression in the digital age. It's a challenge to an amendment made to the information technology rules in April 2023.
Can you give us some background on what this amendment was about?
Certainly. The amendment in question was to Rule 31B of the Information Technology, Intermediary Guidelines and Digital Media Ethics Code, Rules 2021. It essentially gave the government the power to flag content as fake or false and require social media platforms to take it down.
That sounds like it could have significant implications for online speech. What did the High Court decide?
The Bombay High Court struck down this amendment, declaring it unconstitutional. They found that it violates Articles 14, 19(1)(a) and 19(1)(g) of the Constitution of India, which deal with equality before the law, freedom of speech and expression, and freedom to practice any profession or carry on any occupation, trade, or business.
Those are some fundamental rights. Can you break down the court's reasoning for us?
Of course. The court had several concerns with this amendment. First, they found it to be vague and overbroad. The terms fake or false or misleading were left undefined, which the court felt gave too much discretion to the government's fact-check unit.
Secondly, the court was troubled by the fact that the amendment made the central government the final arbiter in its own cause. This, they felt, violated principles of natural justice.
That's interesting. It sounds like the court was concerned about the potential for government overreach.
Exactly, Arjun. The court also found that the amendment lacked the procedural safeguards required under the Information Technology Act 2000. They felt it went beyond the scope of the parent statute.
I see. Were there any other factors the court considered?
Yes, the court also applied the test of proportionality, which is often used in cases involving fundamental rights. They found that the amendment failed this test, meaning its restrictions on free speech were disproportionate to its aims.
This seems like a significant judgment for online speech in India. What do you think are the broader implications?
You're right, it is a landmark judgment. It reaffirms the importance of freedom of expression, even in the digital sphere. It sends a clear message that attempts to regulate online speech must be carefully crafted to respect constitutional rights.
The judgment also highlights the role of courts in safeguarding democratic freedoms against potential government overreach. It shows that even well-intentioned efforts to combat misinformation must be balanced against fundamental rights.
Thank you for that insightful analysis, Arjun. It's clear that as technology evolves, our legal system will continue to grapple with these complex issues of free speech and regulation.
Absolutely, Priya. It's a constantly evolving area of law, and I'm sure we'll see many more cases like this in the future as we try to strike the right balance between combating misinformation and protecting free speech.
Well, that brings us to the end of our episode. We've covered a lot of ground today, from criminal law and administrative decisions to trademark disputes and online speech. It's been a fascinating journey through some of the key Bombay High Court judgments from September 2024.
It certainly has, Priya. These cases give us a glimpse into how our legal system is adapting to new challenges and continuing to refine important legal principles. I'm already looking forward to seeing what October's judgments will bring.
As are we all, Arjun. Thank you to all our listeners for joining us today. We hope you found this discussion informative and thought-provoking. Remember to like, subscribe, and share this podcast if you enjoyed it. Your engagement helps us continue to provide this valuable content.
Absolutely. And don't forget to leave us a review or comment. We love hearing your thoughts and suggestions for future episodes. Until next time. This is Arjun Mehta.
And Priya Sharma signing off from the Ask Junior Monthly Judgment podcast. Stay informed, stay curious, and we'll see you next month.